Mishcon Academy digital sessions.
Good afternoon, everybody, and welcome to this Mishcon Academy digital session on the FCA business interruption insurance test case litigation. I'm Miles Geffin, and I'm moderating this event. I'm delighted to be joined today by Sonia Campbell, Richard Leedham, Ben Lynch QC, and Ralph Fernhead. Sonia is the head of Mishcon's insurance disputes team, and she acts for the hospitality industry group action in the test case. Richard, Ralph, and Ben act for the Hiscox action group in the test case. Richard is the head of Mishcon's commercial litigation practice, and Ralph is the director in Mishcon's insurance disputes practice. Ben is a member of Fountain Court Chambers. He's a commercial litigator with a specialist practice in insurance and reinsurance. We've got quite a lot to cover today, so we're going to begin with a discussion around the test case and its implications for policyholders and for insurers. And there'll then be an opportunity for the audience to put questions to the panel. So if you have any questions, could you please post them in the Q&A panel, and we'll try to get through as many as we can at the end of the panel session. Richard, can I begin with you? Would you just kick off with a brief overview of the test case and explain what it was about and why the FCA brought it in the first place?
Sure, thanks Miles, and afternoon everyone, thanks for joining us. Yes, I mean it seems a long time ago now, but it was 10 months or so ago. COVID obviously hit for the first time, and the government imposed all the various restrictions on us. Very quickly led to a lot of claims being made under business interruption insurance policies, and as we'll touch on in this session, and it is true that there's only a small percentage overall of business interruption cover that is potentially impacted. It's the type of cover that is not consequent on property damage, but there's still hundreds of thousands of policyholders who may have that cover. We were instructed, Sonia and I, different clients very early on, as were in fact many other policyholder law firms, and insurers pretty quickly took a view individually, one has to say, but it was the same view pretty much from all of them, that claims weren't going to be paid out. And then very quickly at that stage, so we're sort of talking end of April, early May of last year, the FCA, having already written to policyholders and to insurers trying to sort of generate some momentum, came up with this plan of using the hitherto, I think, almost completely unknown financial markets list process, so a sort of adjunct to the civil procedure rules, to bring this test case, cajoled one on our side, we don't know, 8 insurers into doing that. We inputted the selection process of policy wordings, and so wordings that Sonia and I and our teams were advising on were included in that case. And the case was run as a test case in the commercial court. Ralph, I think later on, is going to touch a little bit on how the process ran, but it was essentially, it did not involve policyholders or their claims per se. We successfully intervened with, indeed, the support of the FCA on the basis that it was felt helpful to have a policyholder view at the table, as it were. And Ben made submissions for us, as did Sonia's counsel, Philip Eady, in the first instance case, to support the policyholder's position. But the case was run as on points of principle, which we'll very shortly turn to, not on specific claims. And the claim examples that are given throughout the judgment are hypothetical, as in fact is clear from the judgment. So a very unusual case and a procedure that hadn't been used before. At the outset, no one knew quite the nature it would take, as lawyers obviously used to court cases being very adversarial. And there was a suggestion early on that it wouldn't be like that. But in fact, anyone of you who saw the case, although there was obviously no cross-examination of witnesses or the sort of stuff that goes on in many court proceedings, it was incredibly adversarial. No quarter was given on either side. Very serious issues were debated, and two very long and very eminent judgments have been produced. I'll Miles, return to you, but I think we're going to go to Ben next, and to sort of tee up what the case was about. I mean, in essence, insurers were generally taking the view that any of the wordings that Ben will run through that might have given cover were essentially very narrow, locally based restrictions that would impact on a business, and so the national pandemic did not apply to them. And they also argued, again, this is putting it in very general terms, that because the cover had not been intended to be provided for this sort of event, and or because the losses and the interruption would have happened anyway, there was no cover. And that's the sort of causation issue that we'll touch on. But that's the essence, that's the background of where we are.
Thanks, Richard. And as you've forecasted, I'm going to turn to you, Ben, if I may. I think you're going to give us a whistle-stop tour of the disputed wording clauses that were considered by the justices in the test case. And as I understand it, these cover sort of three different types of wording. So if I can just hand over to you, I think you're going to share your screen.
Good afternoon, everyone. Thank you. I'm going to have a look at some wordings. And in my 10-minute slot, I'll almost certainly do justice to the 580 paragraph first instance decision, the 112-page Supreme Court judgment, and the thousands of pages of submissions, which I'm going to neatly wrap up in a 10-minute slot. So I'll talk very quickly. Now, I'm obviously not going to get through absolutely everything. What I'd really like to do is just touch briefly on the different categories of wording. And you'll see the third bullet point down, those three categories: disease clauses, preventive access / public authority clauses, and hybrid clauses. Disease clauses, in large part, do what they say on the tin. They are clauses, these are described, helpfully summarised, paragraph 4 of the Supreme Court's judgment. Clauses which in general provide cover for business interruption losses resulting from the occurrence of a notifiable disease, such as COVID-19, at or within a specified distance of the business premises. Hence the name disease clauses. Preventive access clauses, which in general provide cover for business interruption losses resulting from public authority intervention, preventing or hindering access to or use of the business premises, hence the name preventive access clauses. And hybrid clauses, which combine the main elements of those two. So, looking at some examples, there were lots of types of all of the different types of wording, but it's important to look at the disease clauses wording, some different types, because there was a classic or standard example, RSA 3. Interestingly, there were three QBE wordings. QBE 1, where the FCA was successful at first instance, compared with QBE 2 and 3, where they were unsuccessful at first instance, but successful on appeal. And then RSA 4, where the FCA was successful and Sonia's team was successful at first instance, and no appeal because they were successful. So looking at these, my IT skills were not up to adding a heading here, but you'll see my IT skills were up to essentially cutting and pasting from the wording itself. So sort of swings and roundabouts, pros and cons to my IT skills, but imagine that says RSA 3 at the top. Classic disease clause wording: we shall indemnify you in respect of interruption or interference with the business during the period following any occurrence of notifiable disease. And you'll see ones at the premises, you'll see ones within a radius of 25 miles. QBE 1, and I just flag this for future discussion: loss resulting from interruption of or interference with the business arising from any human infectious, human contagious disease within 25-mile radius or in the premises. And note the difference there, still obviously disease clause, but note the difference there between QBE 1 and QBE 2. This is the QBE 2 wording, still disease clause wording. Infectious disease, murder, suicide, food or drink poisoning, loss resulting from interruption of or interference with the business in consequence of any of the following events. A, any occurrence of a notifiable disease at the premises. C, any occurrence of notifiable disease within a radius of 25 miles of the premises. Now, you may be forgiven for thinking that looks a lot like that. So QBE1 looked a lot like QBE2, although note the word event, and that made a difference at first instance, but not on appeal. But those are a range of the disease clauses, and you'll see that obviously they respond to disease. Now let's look at something really quite different in a way, preventive access. This is the arch wording. We will also indemnify you in respect of reduction in turnover and increase in cost of working as insured under this section resulting from government or local authority action. That's the heading. Prevention of access to the premises due to the actions or advice of a government or local authority due to an emergency which is likely to endanger life or property. And Arch conceded rightly that COVID-19 is an emergency which is likely to endanger life or property. But the key point to note is, why is this a preventive access clause as opposed to a disease clause? Because there's an indemnity in respect to reduction in turnover, increased cost of working, etc., resulting from preventive access, not disease. But it's preventive access to the premises due to the actions or advice of a government or local authority. So those are those two different types. And then, crucially for certainly my purposes in acting for the Hiscox Action Group, and all of our purposes acting for them, this was the hybrid wording, the Hiscox hybrid wording, and you'll see why it's called hybrid, because it's got both the disease element and preventive access or inability to use elements. So here, we will insure you for your financial losses and other items specified in the schedule resulting solely and directly from interruption to activities caused by ... And there were obviously 12 on the list before this, and then some after, but it just so happens this was 13 on this one. Public authority, 13, your inability to use the insured premises due to restrictions imposed by a public authority during the period of insurance. So far it looks like a prevention access type wording, but following C, injury or illness of any part, B, an occurrence of any human infectious or human contagious disease, an outbreak of which must be notified to the local authority. And that's the disease clause element, hence hybrid. Now, just 2 points to flag in particular here, because they were of particular importance on the appeal. The wording, and by the way, the highlighting is as per original. Those are defined terms rather than me erratically highlighting things. Just to flag in particular, inability to use and restrictions imposed. And those points were points on which we in the FCA were successful on appeal. At first instance, inability to use was limited. It was essentially an inability to use the insured premises across the board and really allowed little room for manoeuvre, or at least arguably allowed little room for manoeuvre. Restrictions imposed were only restrictions imposed having the force of law. On appeal, however, the Supreme Court looked at inability to use and said, well, hang on, you can have different kinds of inability to use. You can have a complete inability to use part of the business, or a complete inability to use all of the business premises, or you could still use your business premises, but only for parts of your business activities. So I used to make widget A and widget B. I can only make widget B. I've lost the ability to make widget A. That's a type of inability to use. And another example, I own a golf club and I'm not allowed to use the clubhouse, but I am allowed to use the greens. Well, I'm not allowed to use part of the business premises. And that was a big success in the Supreme Court. Then on restrictions imposed, there was an important question, which was when there were announcements made, for example, by the Prime Minister, that businesses had to close their premises. Technically, that was without legal foundation, or arguably without legal foundation, because the regulations didn't come in until later. So the question was, well, are those announcements telling businesses to close still restrictions imposed? And there are obviously lots of announcements of all different kinds, won't go through them now, but just to take that one example, is that still a restriction imposed, even though technically the regs didn't come in until later? And the Supreme Court said, well yes, it is, because properly construed, the reasonable person would understand that those requirements being mandatory, they have to be clear, it have to be readily comprehensible that they had to be followed, but applying that approach, they would still be restrictions imposed, even though technically the law putting them into effect didn't come in until later. So just wanted to flag those 2 points in particular on this wording. And obviously that's a very quick run through the different forms of wording. And I'll just hand back now to Miles. Thank you.
I mean, in light of what you've said, and of course we all have the benefit of hindsight, don't we? In light of what you said, do you think that the decision of the justices was inevitable and the insurers took the wrong route in all of this?
Well, I'd like to say that the decision was inevitable until they heard my highly persuasive advocacy, and then it all changed. But something tells me that they may have done their own thinking. So, well, it depends. It depends what you're asking about. On this Hiscox wording, for certain categories of claimants, I think a lot of people thought the answer was frankly extremely clear from the outset. On other wordings, there may be more argument. We were entirely focused on this wording, which we thought was very clear, if that's helpful.
It certainly is. So Sonia, following on from Ben's overview and from what he's just said, what are you now seeing practically on disease and prevention of access wordings? Got divorce on the mind?
I'll leave divorce and just talk about disease and prevention. So what we're saying, as Ben said and Richard said, obviously we were delighted for HIGA clients because we have succeeded in showing cover under all QBE 1 to 3 wordings for disease clauses, and actually for RSA4, the resilience marsh wording, at first instance, Philip Eady, Susanna, Joe Higgs, who are on our council team, worked so hard, and we got a great result on that wording as well, which means that insureds have cover. That wasn't appealed. So obviously very pleased for many clients. In practical terms, I think where it leaves people with disease clauses is if you have a geographical radius limit in your policy, and you can show a single case of illness sustained before the relevant government restrictions, then you should be, and there's a case in your radius, then you should be able to claim cover from your insurers. And we are seeing for insurers who are not part of the test case that they are, in certain cases so far, abiding by that decision. So hopefully others will follow in the spirit of what the FCA has expected and what the judgments expect, that they will do so. The Supreme Court's decision is clearly applicable, I think, to insurers who were party to the test case and have these wordings. So those insureds have very clear guidance as to whether they have cover or not. As I say, if you have a wording that mirrors, essentially the wordings that were considered, you would hope that you would also have insurance cover now. Even if your claims were declined early on, those insurers should be getting in touch with you if they haven't already to say that they're going to commence the adjustment process. For the clients we're dealing with, we are seeing that happening, which is good news.
Absolutely.
And a question which keeps coming up at the moment, and I think it's one of the Q&A that I saw pop up, is what happens if you have a disease clause which only talks about at the premises? So I think that the example that Ben put up had an at the premises clause and a radius clause. Many wordings don't have that radius and will just say disease at the premises. And I think that, logic does dictate that the same reasoning should apply. However, there are arguments, I think, on both sides, and insurers, I think, it remains to be seen whether they take those arguments. I think they may do, as to why they say there's still no cover. Those are things we're actively advising clients on, so I don't want to get into too much detail on that. But as I said, logic should mean that those cases should be covered. If those people, those insureds, can show that they had a case at their premises and that was before relevant restrictions, then why shouldn't that be a trigger to enable them to cover in the same way as somebody who has a radius clause of 100 metres and can show a case within those 100 metres. But that, importantly, Miles, I think the point is that that issue wasn't expressly addressed by the High Court or by the Supreme Court. And so it remains to be seen how that's going to be dealt with. There is still an issue of prevalence and proof, and those sorts of issues are still being developed and discussed by the FCA, and I think there'll be more guidance on that in the coming weeks.
Sure. And just in terms of understanding a bit more about the importance of this decision, I mean, are there any sort of, has anyone got an idea as to how many policyholders are affected and what sums of money might actually be involved in all of this?
Well, I think we've seen various numbers discussed, and I think in the context of the test case, the FCA had said up to 370,000 policyholders, potentially affecting 60 insurers, 700 policy wordings, values of 1.7 or 1.8 billion. But I think it could be more. And in terms of the values, we don't know really, because it depends on the claims, and once they're adjusted, what the losses really are. So I think it's a bit early to actually say, well, this is what the figure is. I don't think we really know that. I should say just quickly in terms of prevention of access wordings or denial of access wordings, as they're sometimes known in policies, the position isn't so positive for policyholders. Those clauses generally are more restrictive in terms of the cover that they afford, more restrictive certainly than disease clauses. And at Supreme Court level, the only prevention of access clause which was considered was an arch wording. But in the appeal, it was looking at the force of law and restrictions imposed elements. But the arch wording is interesting because it provides cover for an emergency likely to endanger life or property. Crucially, it doesn't contain what's called in the vicinity wording. And the Supreme Court didn't consider those wordings, which included in the vicinity, because they weren't before the Supreme Court. And so the High Court decision on those issues stands. And so if you have an undefined in the vicinity clause in your wording, generally insurers will be saying you don't have cover, and you have to show that something particular has happened at a particular time in a particular place. So it's a local occurrence, according to the judgment, and I'm sure insurers' position, connoting an immediacy of location. So that's the current law for those wordings. Again, there are some grey areas, and we're seeing different combinations of different types of wording which weren't expressly considered, and so people are seeking advice and seeing what they can do, and in some cases we may be able to help them.
So it's still a little grey.
Yeah, in some
instances.
Yeah, I would say generally more difficult with prevention of access, denial of access, but there are some routes where I think actually there should be cover. But it depends on the wordings.
Thank you, Sonia. Ralph, both Sonia and Richard have touched on the sort of process by which the test case was progressed. I mean, this was an unusual case with considerable, as yet unquantified, commercial implications. Can you just give us a sense of what the litigation process looked like and the speed with which the High Court and the appeal proceedings were progressed?
Sure. I mean, it's, as you've said, very unusual. It's not often, in fact, I'm not sure it's ever happened before, that you've had a regulator taking the companies that regulate court on behalf of their own customers and making arguments for them. So, just in terms of the end of the case, you had the Financial Conduct Authority, you had 8 of the insurance companies it regulated, you had 2 groups of intervening policyholders represented by Mishcon. There were actually 2 other groups that tried to intervene at various points and were told by the court that it wouldn't be appropriate for them to do so. So huge numbers of parties. You had 2 case management conferences which were held before the first instance trial. That lasted 2 weeks, involved both a High Court judge and a Court of Appeal judge. They then produced a detailed judgment. They then produced a set of declarations which were anticipated by the FCA at the outset, and were really there to try and provide a helpful guide for people to interpret the judgment and for law solicitors to look at when actually assessing claims. That wasn't actually the end of the process, because it went on to be appealed to the Supreme Court. But whereas the normal process would involve the High Court, then the Court of Appeal, then the Supreme Court, in this case, the proceedings went straight from the High Court to the Supreme Court. They did so incredibly quickly. We had a 4-day appeal held in the Supreme Court. They produced a very detailed further judgment. Ben's mentioned how many documents there were. Literally tens of thousands of pages of evidence, over 1,000 pages of legal submissions. This was all held entirely remotely. So there was never anyone physically present in a courtroom. As with everything due to COVID, we're now used to this. But going back to the time the case was heard, this was something which I don't think any of us could have imagined happening 18 months ago, before we came into this world. And so you've had 2 very serious court cases with huge numbers of parties, huge numbers of documents, all held remotely, all streamed over the internet, and it's all happened pretty seamlessly. Is
this the future for litigation moving forward then? Sounds like it's incredibly efficient.
Yeah, I mean, I'm sure people will miss courtrooms and go back to them, but I think it's shown that a lot of this can be conducted remotely, and I'd be amazed if that disappears as we go forward.
I think I agree. Richard, if I can just turn to you about the wider application of this decision. What does the Justice's decision mean in relation to causation generally? Is Richard with us? No, I think maybe he's dropped off. Can I maybe turn to you, Ben, on that question, whilst Richard rejoins us?
No, absolutely. It's a fascinating issue, because views differ on this. Some say that these policies were never intended to respond to pandemics, and therefore the court has had to sort of play around with causation to reach a result. Personally, I don't agree with that. The proper approach to the construction of a policy is you look at what it says, and you don't look at it with the benefit of hindsight. But there are plenty of authorities, and it's a point that we made in arguments, which is there's a well-known case called Bromerin, which was then considered by Lord Justice Leggett, as he was then in the Aquitas case in the Court of Appeal, which says that what you do is you look at the wording as a reasonable objective person, i.e. standard approach to construction, at the time of the events, even if those events were not foreseen. So foreseeability or otherwise isn't really the touchstone of construction. Where does that take us with causation? Well, what it means is that what the court was doing was construing these policies. They weren't playing around with causation as a concept. They took, it was interesting, and it was very advanced, and it was progressing the law, but it wasn't antithetical. It was a very sophisticated approach to causation, and it didn't borrow it. It read across from concepts of causation in other areas of law. So, for example, a great thinker, modern-day jurist on causation is Professor Jane Stapleton, and she has done a lot of work on this, and she has written about what are called oversubscribed causes, for example. So 20 people push a bus over a cliff. It would only take 15 of them. Can you say any one of them was the cause, etc.? And here, that issue came up in lots of different ways, but most obviously it's an extreme case, of course, because one case of COVID, well, so what? But if you say that about all of the cases of COVID, then you take away causation entirely. So what that means across the piece in terms of causation, well, it's very interesting. It's not new It's just a new application of areas of law where a lot of great thinkers have already applied their minds to it, but more in the tort area. So I agree, could lead to interesting developments.
So Sonia, in light of this, in light of the decision, in light of what the justice said on the causation point, what's actually happening on the ground now with claims?
I'm going to pass you over to Ralph on that because he's dealing with this, Miles.
That's absolutely fine.
Okay.
Sure. I mean, I can tell you, if I start with what should be happening with claims. So the Supreme Court case, as we said from the outset, didn't actually consider the claims of any individual policyholders. It considered the arguments being made by the insurers for denying claims. And it's held very clearly that in a large number of cases, the arguments being made by insurers to deny the claims were wrong. So the question is, having been told that they denied the claims wrongly, what should insurers now be doing in respect of those claims? And the FCA has said consistently, and it's reiterated this following the judgment, that they should now be writing to all their policyholders, writing to all their brokers, telling everyone concerned with these policies that they are now reconsidering them and that they are reviewing them, and that some of them may now be covered, even claims that they were previously denied. And where that is the case, then it's been made very clear by the FCA that insurers should be acting very quickly. They should be telling people they do have cover. They should be moving very quickly to adjust those claims, work out the quantum of the loss. But also, importantly, while they're doing this, because a lot of these businesses have been really badly affected, they should be making interim payments. As soon as they establish cover is still there. So that's what should be happening. We haven't yet seen it happen with the case we're looking at on the Hiscox claims.
Is it usual? Sorry, Ralph. Is it a usual situation for the regulator to be taking such a forceful approach?
No, not in what we've seen in the past. Insurance is an area where the regulator has been taking more and more of an interest over the last few years. If you go back 5 or 10 years, insurance was very lightly regulated compared to, say, other aspects of financial services and banking. We've now had this test case, which has shown the regulator acting, sort of bearing its teeth, if you like, and it's clearly very motivated to see it through to conclusion and to see it actually does have the effect it wanted it to, which is resolving claims.
Which is perfectly understandable. And it's difficult for anyone to disagree with that. But of course, you've described the process, and of course, we've got businesses that have been affected now, going back however many months since this whole awful situation started. So what's the situation now with businesses that are in difficulty or have gone bust in the intervening period because of the insurer's response to their BII claims?
Yeah, so it's something that's a live issue for the claims we're looking at for Hiscox, certainly. But I know from other questions people have asked, and I think I may have seen it on the Q&A as well. It's an issue which affects lots of policyholders. It's been almost 10 months to the day from when the Prime Minister first announced the first set of COVID restrictions in the UK, and bar a few exceptions, most people who put in claims who had this cover have yet to receive any money. Now, in that intervening 10 months, it's been a very difficult time for businesses. Many have had to lay off staff. They've been unable to afford to keep on their premises. They've been doing what they can to meet ends meet, and sadly, some haven't been able to. Some have gone into liquidation. We have half a dozen clients in the group of Hiscox policyholders we represent for whom 10 months was just too long, and they're no longer there. So, the question is, if that could have been avoided had they had their claims paid back in April when they submitted them, and insurers hadn't denied them for the reasons that the Supreme Court's now found were wrong, should they be entitled to more than insurance money? Can they claim back the additional costs of recruiting new staff, having to lay people off? Can they claim the cost of renting the office space, having, if you're a restaurant who's lost your prime city centre location because you couldn't afford the rent? Can you do anything about that? And traditionally in English law, you couldn't. because there was no additional damage routes against insurers. You either got your claim money or you didn't. And if the insurer took a long time to pay or denied it unfairly, there wasn't much recourse. But that's changed recently. It's about 4 years ago now, we had an additional provision introduced into our Insurance Act, provision 13A. And what that means is that it's an implied term of every insurance policy that if your insurer unreasonably delays in making your payment under your claim, you have a right to damages. Now, the reason this is very topical is because it's quite a recent provision and it's never yet been before the courts. So we still don't know from what unreasonable means, and if insurers have acted unreasonably in delaying your payment, what damages you can claim. But it seems fairly clear, at least to us in this case, that where these are insurers who have had the reasons they gave for denying claims turned down by the High Court in unequivocal terms, and now turned down unanimously by 5 law lords in the Supreme Court, that that denial was unreasonable, and where businesses have suffered losses as a result, that this should be an example where this provision, this is exactly what this provision is catered for. And I say that not just because I think that's the right answer, but also because I got a phone call from one of the draftsmen and one of the law commissioners who started to draft this provision before this even started and even got to the High Court, and he was calling because he'd heard we were acting, and he thought this is an ideal case to test this out on, and he was hoping we were going to do so.
Sorry, now we've got Richard back. Can I just come across to you on this question, which is, bearing in mind the approach that the insurers to the whole issue of BII, I mean, are they going to throw their hands in on this issue of damages because of the way that they conducted themselves unquestionably, query unreasonably, and led to delay, which has caused additional damage? Or do you think that's also going to end up being litigated?
I think, as hopefully everyone can hear me, and sorry for my IT outage. Another factor of the last 10 months of work, obviously. I think, as Ralph's alluded to, it's a live issue in our ongoing claims with Hiscox, and to be clear about that, those are in arbitration. That is a matter of public record. It was mentioned by Hiscox's counsel in the Supreme Court hearing, but obviously I can't say anything more about that, and it is a live issue. I think, stepping back from the arguments we're running, one can see that, of course, there are certain policies that were argued over before the Supreme Court, and not the Supreme Court, the first instance court, that insurers won on. And they will say, well, it was entirely reasonable to run arguments that we did. We won on some of the points, we lost on others. And you, Mr. Policyholder, haven't got a complete home free run on absolutely everything. And it was right for us to fight those cases. And that's an argument we're going to have to deal with, because it's not as if it was a one-off case, one policyholder against an insurer. As I said earlier, policyholders weren't involved in the case apart from anything else, where the defendant insurer was found to have behaved unreasonably and should have paid the claim from the very beginning on points of principle. But I think against that is you've got sort of fundamental principles of English law, that when a judgment comes down on a case, that is how the law always was. And it does give you the starting point to say, well, okay, and I think where this will go will be on, and Ben alluded to this earlier on some of the wordings, as we had clients at the very beginning saying to us when they came to us, saying, look, this must be covered. I don't understand what Hiscox is saying, coupled with various examples of having been told as they were buying the policy, just as the COVID restrictions, the restrictions weren't happening, but COVID was hitting, yes, this will cover you for this type of loss. And then they fight through, as Ben was saying, we ended up with thousands of pages of documents, 3 weeks of court hearings, 3 or 4 other interlocutory hearings, to be told in no uncertain terms, if you read the judgment of Lord Briggs tucked away at the end of the Supreme Court judgment, it's a brilliantly devastating critique of insurers' overall attitude towards these claims. And I think it may well fall into which of the claims that are being denied and on what basis. And where there was a clear claim under a policy wording for a business that was quite obviously shut by the restrictions, wasn't paid out for 10 months, has quite potentially now either gone into some form of liquidation or is facing that, has had severe business losses as a result. It seems the paradigm case for this legislation to compensate that policyholder.
Indeed. I'm just on this question of damages under the insurance policies. Ralph, if I can come back to you, I've seen there's been quite a lot of sort of noise and debate around the question of whether the policyholder or the insurer, well, rather the insurer can adjust the claim relying on receipt of furlough monies or some other grants that were received from central funds. Is there a sort of collective view on this as to how likely that's going to be?
Sure. I mean, it's a question lots of people are asking, because a lot of businesses, all across the UK, receive furlough payments to help subsidise their staff costs, or they've received other forms of government fund to keep them going through this, through what's been a very tough time. There's no definitive answer to it either, because we've never seen furlough payments. We've never had to adjust furlough payments before. 10 months ago, no one had ever heard of a furlough payment. It's only a concept which, effectively was invented, by the government to address COVID and the issues it was facing. So the question is, can insurers take credit for those payments, which were, emergency subsidies funded by the taxpayer, and can those payments be used to reduce the amount of money they're going to pay these insurers? The way I look at it is, should privately owned British insurance companies profit from emergency government funding funded by the taxpayer, which was never intended for them? So, that's a, might say that's a sort of very biased way of phrasing the question or rephrasing the question. But it's not just me. That's the way the government sees it too. The Treasury wrote back to the Association of British Insurers after the first instance judgment on the subject of government assistance. I'm just looking at the letter before this, because I know it's a live topic, and what they say in that is, it's the government's firm expectation that grant funds intended to provide emergency support to businesses at this time of crisis are not to be deducted from business interruption insurance claims. The principle of these grants is to provide emergency support to help businesses survive. The practice of making these deductions would mean that taxpayer funds are being channeled into savings for insurers rather than support businesses to ride out the disruption brought by this pandemic. And they've said if insurers do adopt that practice, they might look to intervene. Now, that's specifically in response to a letter from the Association of British Insurers, where they were saying, don't worry, we won't deduct the following grant payments, and they refer to particular types of grant payments. So not in the context of government funding overall, but it's very clear that's the government's view. The FCA has said, as the regulator, insurers should think very carefully about their treating customers fairly obligations when they are adjusting those payments. They haven't yet said, come down with a furlough, but that's a clear steer. They're thinking about it, so they may well say something more on it if they feel that particular insurers are not treating customers fairly and are not adjusting those payments as they should be made. You also look at the construction of these policies, which say, you have cover for your loss of income. So what you have to look at is, were these government assisted or pieces of government funding income in the sense that they would normally be understood by a business, or in that they're understood under the policies? And certainly under the policies we've looked at, they define income as income being income for the business's usual activities. Now, receiving a government subsidy is very different from receiving, your normal business income. So I think, taking it all together, I think no, they shouldn't be deducted. If they are deducted, there's going to be a fight. And I think that may well be happening soon.
So certainly, I mean, it's interesting. I'm seeing quite a few questions popping up on this very point, and I think there's clearly there may be a difference of opinion amongst people. Richard, you have your hand up. Was there something you wanted to say on that point?
Yeah, I just want, because it is a very much a live point, and not least as many businesses are now in their third lockdown and getting, furlough has obviously been extended throughout the period. It's just worth reiterating Ralph's points, but by reference, and it may be he focused on this letter in other contexts when I was unfortunately offline, but the Dear CEO letter that the FCA sent out to all insurance company chief executive officers last Friday, the 22nd of January, makes it clear. I'll read out what it says. The paragraph says, "We expect insurers to have considered the treatment of government support at board level, and for this consideration and the conclusions reached to be appropriately documented. We will follow up with insurers individually where necessary, continue to consider the appropriateness of deductions of other forms of government support." And the previous paragraphs highlight the letter that Ralph read out from the government in response to the ABI. And it's clearly, the FCA are not saying they need to be removed from the calculation, but there's a pretty strong steer that insurers have to be very mindful of what others are saying about this, and not in the context of their treating customers fairly obligations. And one would hope that the penny will drop, and that one would also hope that the FCA then bare their teeth via the enforcement route if insurers are found to be not treating their customers fairly.
No, of course. I mean, so Ben, just before we move off this subject, I mean, these are pretty clear steers from the regulator and from government. They're going to be pretty persuasive to a judge, aren't they, who's going to have to determine these issues at some point? I mean, maybe 3 judges or a panel of 5, 7 or 9.
Yeah, absolutely. I think it will depend on what's said and the detail of what's said, first of all, so have to be reviewed closely. I then also think that if the message is clear, I think in large part the insurers will follow the clear message. So my hope, in fact my expectation would be, where there's a clear message, it won't lead to disputes because the message will be clear. But I think there are a lot of stages in there as to first of all the clarity of the message and how that's to be put into effect.
Of course, thank you. Before we turn to the questions from the audience, and there's quite a few of them, I think. I just want to very quickly just ask each of you in turn just a very quick question. So first of all, Sonia, can you just confirm what policies are categorically covered by the decision, and what should policyholders be doing when the situation is less clear?
Okay, well, maybe you can start from which policies aren't covered, because I can see from some of the questions coming up, where for disease clauses you have a specific list of diseases which doesn't include COVID, and it won't, because your policy would have been in place before COVID was known about. COVID became a notifiable disease on the 5th of March for our purposes. If you have a list that just lists diseases, or it says notifiable disease and then notifiable disease is defined as a specific list, that's called a closed list, and you won't have cover under that policy unless it has additional wording that says or any other disease that becomes a notifiable disease, etc. So where we're getting a lot of questions about, well, I've got disease cover but they're saying I'm not covered, quite often it's because of that reason. At the premises, we're seeing lots of questions about that coming up. As I say, I think it's arguable, and I think it's grey because it hasn't been determined in terms of if specific people on this call have particular questions and they want us to look at something, then I'm happy, subject to volume and being completely inundated, to look at those issues, because I think we probably can give quite clear guidance quite quickly, but it's difficult to do so generally on this kind of call. If you're looking at a wording that was addressed by the courts, a specific wording with a specific insurer, you know what that decision is, that should be clear. If you're looking at wordings which mirror those looked by the courts, you would also have some clear guidance. And if your insurers are saying no cover when you think there should be cover after the High Court decision, and following the Supreme Court decision, I think you should be looking back to see whether the position has changed, because for some of our clients, where we won at first instance, even though there was nothing discussed on appeal, I think the Supreme Court has improved prospects of recovering more from insurers. So I think you should definitely look back. And as I say, there are some issues that remain unresolved in the facility at the premises. They're things I'm advising on. So if people do want to discuss them, I'm happy to be contacted.
Thank you. I think we should probably move on to the questions from the audience. We've only got 10 minutes left, but just very quickly, Richard, what's your view as to what this decision now tells us is going to be next for insurers? You're on mute, I think.
Yeah, I think there's a crossroads now, and it's again picking up on some of the questions because I know we won't have time to get to them, but I can probably deal with a couple. I think the last 10 months in the insurance context here have completely polarized opinion. You've got policyholders, and yes, we represent them. We're on that side of the fence. Think insurers should, put their hands in their pockets very quickly when everyone else was, to some extent, particularly sort of government. We all had to adapt and do different things, and they were seen as not doing that. The insurer side, and one of the questions, this was never intended. I mentioned it earlier on that they weren't intended to cover pandemics. They weren't designed for this. Those wordings were certainly historically aimed at localized shutdowns of businesses for sort of local disease or bomb scares or whatever. But the fact is that has been fought out in the most serious way possible before now 7 very senior judges who have all found that those arguments aren't right. The underlying arguments on causation, intent of the policy, the intent of the policy never even really came up in any of the legal debate. It was what we thought sort of underpinned insurers' arguments on causation. They were trying to argue something to demonstrate that they hadn't intended to pick up these losses. The court's been clear about that. Of course, on particular wordings, as Sonia has said, there'll be uncertainty. They've won on some of the wordings. They've clarified that. It really is time for them to step up, pay the businesses that they should pay, read the Dear CEO letter, make the interim payments that need to be paid, whilst the more complex issues of adjustment. There's no one saying BI losses, even for small businesses, are necessarily straightforward. They need to be adjusted, but money needs to start flowing from the insurance industry, who receive billions of pounds of premium. I'll just end on one stat I read. They've saved £4 billion. I don't know if that's globally or just in the UK, from not paying out on motor claims because of the lack of motor accidents during the pandemic. If that figure's accurate, they've got the money to pay these claims. They should be paying them.
Thank you, Richard. I think we can maybe turn to some of these questions. There was one that came through which I just saw, which I can answer actually. There was somebody who has asked whether this event, I think they had to dial off early, and they asked whether this event was being recorded. I can confirm it is being recorded. There'll be a film which we'll distribute afterwards. So if anyone's missed anything, they can pick up on it afterwards. I don't know, each of you, whether you've seen the questions as they're coming through. I think we've made it clear it's very difficult for us to comment on specific clause wording.
Miles, can I just one point that I think I can touch on, which is about landlords and tenants and real estate. So we do act for a large number of insureds who have property owners policies. So you have this landlord tenant issue, and it's more complicated. So those policies were carved out of the FCA test case, so that they're not directly dealt with yet, and the issues raised are more complex. They raise property issues, real estate issues, lease issues, and so if people want advice on that, it's not clear cut, and I think they need to seek legal advice from us or elsewhere if they have other lawyers acting for them. But it's not something that's just directly transferable. However, in those policies, they do have the same underlying disease prevention of access clauses that have been considered and determined by the courts, and so there obviously they are relevant, and it remains to be seen what's going to happen to the cases that are going through the courts on those policies.
Miles, I can pick one other as well. There's a question about the declarations that will come out after the Supreme Court judgment and whether Mishcon are involved in those. We are involved as an intervener, the Hiscox Action Group are involved in trying to agree those declarations, and if they can't be agreed, they'll be back before the court quite quickly. All I would say about that is that the aim of those declarations is really to make it easy to understand what the court has decided policy by policy. If you have the relevant policies in one hand and the declarations in the other, that will help you. Of course, the Supreme Court judgment stands as a judgment on those wordings and other points of principle.
Thanks. I've just seen, and this I guess this is a kind of commercial question, but it's quite an interesting one. It's from Sally Wollaston, which she asks, what's going to happen with business interruption wording going forward? And are clients going to, or policyholders, going to be forced to accept wording on renewal which will exclude pandemics in the future? I don't know whether anyone has a view on that, but it's...
Yes. The clients that we've all got, many of their policies have come up for renewal during this period, and I haven't seen one policy that doesn't have an exclusion for contagious or infectious diseases. I don't know if anybody's got a different perspective where they have seen that cover continue, but these policies, in terms of how they operate, it's very clear now that on renewal there won't be cover, in my view.
I mean, our sort of experience of that from policyholders on the smaller side is, and again, this touches on another question, is why on earth was I sold this BI extension, which was never going to respond, and we've had such a big fight on, and now I can't get in the future. I think a claims against brokers for this is going to be quite difficult, and that's probably the subject of a whole other webinar, not to get into that. But I think the SME community is incredibly disillusioned with cover that they got. The issue, as Sonia says, will probably go away because they won't have this cover in the future, but you'd have to question whether they would want to pay for any sort of business interruption, non-damage business interruption cover, and just limit their BI to damage to their premises. And at the other end of the spectrum, for much larger clients, I was talking to a large-ish business the other day who has a claim under the resilience wording, which, as Sonia says, her group in the FCA won at first instance. It wasn't even appealed. He still hasn't been paid his claim. And his approach is, going forward, he will just treat BI as a sort of catastrophe high excess cover. So he will buy it for a much smaller price at a very high limit of, perhaps above $1 million or $2 million of that sort of catastrophic loss to his business. Then he'll have some protection. But within that, he will just take non-damage BI for his own account because he's completely disillusioned with the insurance market.
Which I imagine a lot of people are feeling. I think one last question before we finish, and maybe this one's for Ben. It's a relatively easy one, but you never know. We're asked, will insurers involved in the test cases who operate in other jurisdictions be bound by the UK Supreme Court decision in those jurisdictions? I mean, we have an international client base, and I think this has been an interesting question for a lot of them, and Sonia and I have been doing some work for a mutual client in relation to that overseas. Yeah, absolutely. Well,
that's a question that obviously has multiple answers depending on what's meant. But if the question is an insurer providing insurance services here, yes, they will effectively be bound. If it's an insurer providing services elsewhere, there are test case proceedings going on all around the world. I think recently, just one example, Ireland has delayed their proceedings to look at our Supreme Court judgment, I read recently. But there are plenty of others happening all around the world. And it may be that our Supreme Court judgment is regarded as helpful for assisting determine those disputes. But it may not be, because the law is so different in those areas. So obviously it'll be a matter of where the insurance is being provided that will answer that question.
Thank you, Ben. And with that, I think we're now almost at 3 o'clock. All that remains is for me to thank our panelists and you, our audience today, for what I think has been a very lively and energetic discussion. We hope to see you all very soon in the future Mishcon Academy digital sessions. So thank you and goodbye.
The Mishcon Academy digital sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.